And so Caryn Sternlicht, our presenter, she works at Washoe Legal Services. She's an attorney in our consumer and housing department, but she did spend a lot of years representing victims of domestic violence, doing both family law and helping them get protection orders. So she is quite experienced in this area, and we're lucky to have her here presenting today.
I think I want to start by talking about, what is domestic violence. Clearly, if somebody, well, before we talk about what is domestic violence, let's talk about that in order to get a protection order, there needs to be a certain relationship between the applicant, the victim survivor, and the adverse party. So for example, if somebody is a domestic partner, if somebody is a spouse, that's what we tend to see a lot. But there's other categories which also qualify. For example, a parent and a child, a parent and an adult child, a child and an adult parent. People
Siblings, I've seen that.
Well, actually, siblings is now excluded. As of the new session, as of the new laws, and in fact, that's what I was going to kind of get into. There's certain things that were included, like Rita said, like siblings, that are no longer included. Does that mean that the sibling who's the victim doesn't have a remedy? No, it doesn't mean that. But it means they're not getting a domestic violence order. They would have to go to justice court and apply for a restraining order, okay, a stalking and harassment order. For example, the other category is roommates. Now, if the roommates are in an intimate relationship, that qualifies. But if they're just roommates, that used to be covered, it is no longer covered. Also, I believe that the new legislation also excludes, it excludes cousins too. So it used to be, again, so those are the kind of familial relationships that are now excluded by the new legislation that just went into effect July 1st, okay? So once you meet that threshold of there's the requisite relationship between the applicant and the adverse party, you get to, well, what is domestic violence? Now, clearly, if somebody throws a rock at your head, if somebody pushes you down a flight of stairs, that's clearly domestic battery, correct? Now, I want you to understand that when we're talking about, let's take the act of somebody pushing, a wife pushing a husband down a flight of stairs, or two people who are in an intimate relationship. I want you to understand that applying for this protection order, this is civil. This is not criminal. So that same act of somebody pushing somebody down a flight of stairs, that's also what we would call battery, right? Okay, so the same act that may result in a civil protection order may also result in someone being arrested and charged criminally. Okay, these are separate things. Now, a lot of times you'll see, especially for those of you who are caseworkers, that in cases where the adverse party has pending criminal charges, the victim will also get what's called a no contact order. Okay, now that's a criminal no contact order. Does that mean that you don't need a protection order? No, it absolutely does not mean that, because the protection order on the civil side is much broader, and we'll talk a little bit more about that. So I just want you to understand that we're talking about civil versus criminal. So why is that important? Well, to start with, the level of proof, the burden that the moving party, which is the applicant, has to meet is much lower, okay, than you would have to meet in a criminal case. We all know in a criminal case, someone's charged, the prosecutor has to prove his or her case beyond a reasonable doubt. In this civil context, it's a very, very low civil burden. It's basically the equivalent of more likely than not. Okay, so it's the lowest civil burden that an applicant going forward has to meet. That's a really important thing, because just to contrast, there are other civil burdens. Like, let's say that same applicant is going through a custody case. Well, in a custody case, it's also civil, right? It's not a criminal case, but it's what's called clear and convincing evidence. It's a much higher civil standard. So I want you to keep that in mind. You have criminal cases, you have civil cases, and even in civil cases, you have different types of burdens. Protection orders, luckily, are the lowest of the civil burdens. Okay, I want to talk a little bit more about what is domestic violence. Again, we already mentioned somebody pushing somebody down a flight of stairs. Clearly, that's a battery. It can also be a crime. But now you're getting into other things, other acts. People always have questions. Well, what about if somebody's telling me that they're going to they're going to beat the living shit out of me, or they're going to kill me, or they're going to do whatever. So I don't know. What do you guys think? Do you think that that's domestic battery?
assault of threat, so it would qualify for a protection order, but battery is being criminal.
We're not talking about battery now. We're just talking about somebody threatening to commit a battery.
Okay.
So what do you think? What do you guys think? I mean, I know the answer, mostly, not all the time. I mostly know the answer. Here's the deal. Somebody, people say all kinds of things in the heat of the moment. Clearly if somebody tells you, I'm gonna kill you, or, for example, a lot of what I've heard is a variation on, I'm gonna throw you in that mine shaft in the desert and no one will ever see you again. I'm sure the caseworkers have heard variations on that. Now, does that mean it's okay? No, of course not. Does that mean if it's one isolated incident that it's gonna be enough to even meet the burden for a civil protection order? It depends. Again, what the master is looking at is the behavior in context. What else goes along with it? Is it one time? Is it many times? The same thing goes along with, for example, somebody sending letters. I can't live without you. I can't live without you and you can never leave me. Well, if there's one note like that, if there's one letter like that, that in and of itself may not be enough. But I can't tell you how many cases I've had where it's not just one letter. It's like, I can't live without you. Then there's text messages. Then there's flowers showing up at the door, then there's, telegrams, and there's all kinds of stuff. Again, you're looking at the behavior in context, and that's exactly.
Course of conduct.
Yeah,
right?
Yeah, although they don't use that word anymore, but yes, exactly. You're looking at the totality of the contacts between the parties. Does that make sense? Okay, so let's talk about some of the other behaviors that have not traditionally been thought of as domestic violence. And the reason I'm mentioning this is because there's been a great update that the legislature did effective July 1st. There's something in the law called coercion. And without going into a whole bunch of mumbo jumbo about what coercion is, let's say somebody tells you, let's say there's a pet in the family, and that person is telling you, that adverse party, that, if you don't do this, if you don't have sex with me, this dog is gonna die tonight. Or if you don't calm those children down, I'm gonna be skinning this cat alive. Now, by the way, these are all things that, we've all heard. It's sad to think how commonplace these kinds of behaviors are. However, that's where you're getting into coercion. And the legislature in this session, effective July 1st, added to the statute the word coercion. So coercion might also be constant threats. I'm gonna blow my brains out if you leave me. I'm gonna effing kill myself and your mother, and your effing mother too, and those kids. So that is where you're getting into coercion. Now again, I want you to understand, we're talking about it in a civil context. Coercion is also, or can be, a crime. So do you see that these same behaviors may be civil, they may be criminal, okay? Obviously what's important is that on the civil side, it's a really low burden that the applicant has to meet, okay? Also, the applicant could go forward on his or her own on the civil side. On the criminal side, they may not get to decide if there's, probably not, if a criminal case is going to go forward or not, okay? So let's talk about what, I'm going to read to you now, I'm not reading the statute, but what traditionally the statute has defined as domestic violence. A battery, an assault. So again, an assault is like a threat. I'm going to kill you. Compelling the other person to do things or not do things. A sexual assault. Sexual assault, again, sexual assault is also a crime. But again, this is specifically enumerated in the statute. Sexual assault is domestic violence in Nevada, okay? Now, they've actually changed the language here. It was that stalking and harassment was a definition also of domestic violence. It still is. However, the way the statute used to be worded, and this is really important because I had a case, I could not believe what Judge Weller did. Okay, a knowing, purposeful, or reckless course of conduct intended to harass the other person. Such conduct may include, but is not limited to, stalking, arson, trespassing, larceny, destruction, carrying a concealed weapon. Now, they've actually taken out, the reason I said I couldn't believe what Judge Weller did, because the way the statute was written, It was a knowing, purposeful, or reckless course of conduct. So interestingly, I had a case where the woman who came to me, her ex-boyfriend, who was the father of this child, murdered the kid's puppy in front of the kid. Yeah, and it became this whole big thing. When I say he shot the puppy, and came up with this whole big story. Oh, the dog was violent. It was ridiculous. So what happened is, Judge Weller, he's like, well, wait a minute, we have a problem here, counselor. Well, what's the problem, Judge? I mean, it was just horrendous. Even hearing it. I mean, just hearing, thinking, and the kid was 5 years old, or 5 and a half. It's just horrendous. So the judge was hung up on the fact of the statute saying a course of conduct. A course of conduct means more than one time. So Judge Weller is like, I can only think of the words in another language, but Judge Weller's like, well, counselor, this is not a course of conduct. This is a one-time thing. Do you see how asinine that is? What does that mean? So that means if one time an adverse party murders the victim, oh, so what? We don't have domestic violence because it only happened once. So of course that was my argument to him. So actually they've changed the language. I didn't know this, but actually one of my colleagues at Washoe Legal told me that they've changed it to, first of all, they've added domestic violence coercion, which we've talked about. They also added burglary. So burglary, of course, is a crime. Somebody breaks into your house, they're burglarizing your house. But clearly what happens a lot with adverse parties is they go into their exes or their applicants' homes. Home invasion as well, which they've added. And they've also added, the bill also removes siblings, which I said. They've also added, they've taken out cousins. Where is the thing where it says about, okay, so here they've changed it, they changed it to a malicious course of conduct. So they've taken out the word purposeful or reckless. This gets into a whole legal argument, but now they've kind of downgraded it where you have to only show malicious conduct. So it's a lower standard that they've tried. Again, this case I have with Judge Weller, he did not grant, we wound up winning the case because we were there in district court anyway, so we did not get the protection order, but he wound up not being able to have any contact with the kid because we were there on a custody case. But I found this to be absolutely unbelievable that a district court judge was telling me that because there was no course of conduct, that my client, on behalf of her little boy, was not going to be able to get a domestic violence. Now, he was arrested, this guy, and there actually was a criminal no contact, which we've kind of talked about too. Okay, so the definitions of domestic violence. So clearly if somebody is harming a pet, threatening to harm pets, by the way, there is a whole class of abusers that do harm pets. This is one of their, it's just true. I was shocked to see how much of it there really is. There's also so there's also something else that was added, which I think is great. They've enhanced the crime of domestic violence committed against a pregnant woman. Now, the reason that's fabulous is because while I was doing this work, there was definitely a subclass that were very into abusing animals, but there's a whole class of abusers that abuse pregnant women, and I saw really a lot of it. Threatening to kill the unborn child or the fetus, throwing women downstairs, punching them in the stomach, a lot of that as well. So they've actually enhanced it. Now remember, that's on the criminal side, but clearly that woman who's pregnant would have no problem getting a civil protection order, but they've enhanced the criminal penalty if somebody commits an act of violence against a pregnant woman. I think that's great. That's new. That's also as of July 1st.
Any act of violence?
Well,
Just
it's domestic violence, yeah.
okay.
So again, we're looking at the statute. I mean, remember that, on the criminal side, it may not be called domestic violence, it might be called battery, or battery causing substantial bodily injury. It might not have the same name, but it's domestic violence because of who it's between. Does that make sense? Okay. So there's been a lot of changes in how applicants apply. I want to stop here. Before I talk about the whole application process, I want to stop and talk about, see if there's any questions about either what constitutes domestic violence. We'll talk a little bit more about, the procedure for getting one, which has changed a lot. But let's just stop here and let me see if anybody has any questions about civil versus criminal, or what the definition of domestic violence is. Yes?
I have a quick question, Caryn.
Yeah.
You mentioned that like the criminal no contact order is, that the civil protection order is broader. Can
Mhm.
you just talk about that a little bit? Because I think the consequence is the same if they're both violated, right? The person could end up in jail.
Absolutely. I mean, one of the benefits of getting a civil protection order is that if a person, if the adverse party violates it, they're subject to immediate arrest. I do want to just follow up on what Rita said. The whole point of a criminal no contact order is that it's limited to the victim. Okay, that's it. So for example, most of these cases that go forward, there's a family unit of some sort. It is not going to address issues with the children. Also, it's not going to address issues of whether the victim survivor needs support. I'm talking about like child support. I'm talking about, financial support, because domestic violence is an economic crime as well. That's what it is. Emotionally, psychically, spiritually, it's a crime of isolation, but in actuality, it's an economic crime. And that's the big deal, because once the victim is isolated, once the victim is cut off from his or her supports, and the money is controlled, the sex is controlled, the access to birth control is controlled, then that's the arena you're moving in. But in answer to Rita's question, the criminal no contact order is just to protect the victim. You'll see when we talk about the kinds of relief that a court can order in a protection order case, how much broader and more encompassing it is. Does that make sense? Okay. So,
Question.
yes.
Follow-up to that, is not the criminal sanctions for a separate charge for violating a restraining order?
Yeah.
With a greater penalty than a civil contempt of court for violating like a civil TPO? 6 months versus the 25 days?
Well, yeah, you're getting into a whole contempt thing, this may go like beyond what we're doing. I do want to say though, that let me just say though, in response to what Mark said, even though it's a civil protection order, if the adverse party violates the protection order, then that's a crime. So the violation of the civil protection order becomes a crime, okay? Now, I'm not gonna get into like, where do you bring that for? That's like beyond what we're doing here. But I do want you to understand that even though it is civil, the violation becomes criminal. If somebody has a criminal no contact order, and for example, maybe they're out on bail, so their bail will be revoked if it's proven that there's a violation of it. So that can both happen at the same time. In other words, that criminal no contact order will be in place, and so will the civil protection order. They may have what's it called, Venn diagram, where the overlap. Oh my God, can't believe I remember that. But yeah, really. But again, it's much broader in terms of what's in the civil protection order. However, it's much more serious if one violates a criminal no contact order, because clearly there's a criminal case pending. Does that make sense?
Yes, thank you.
Okay.
But my question,
Yes.
that was just a follow-up to that is.
Yes.
And this comes up quite often. I understand the imminent threat. Something just happened, I'm applying for this restraining order. Is there a statute of limitations? How far back can the courts look to prior bad acts? Like, we've been getting along, but he did something to me a year ago.
Well,
What is is there any fuzzy math as far as when the court would say, well, it was too far in the past, you've had another child since then, so that's not relevant, or is it all relevant? I mean, what is your view?
Well, fuzzy is kind of a good adjective because it's not really clear. And the reason I say that is because when I was doing the domestic violence, the advocates were helping at the TPO office on the 3rd floor of the courthouse, were helping mostly women, men too, fill out these applications. And I would always have a problem where they would focus them only on that one act. You know, it's kind of like, no, that's not how domestic violence works anyway, we all know that. And so there's always kind of a fine line between what you want in the application, and is this more important now? Because I'm kind of interrupting myself, but it's more important now because in the old days, they used to interview applicants. When I say they, it was the masters. So they would do a little in-person interview with an applicant prior to issuing the order. And those were recorded. The reason there's big due process issues with that, but anyway, they were. And then they would either grant or deny or do an order to issue, an order for a hearing to see whether a domestic violence order should issue. So there's they're not doing that anymore. So it's completely on the application. Whether it's granted, whether it's denied, or whether there's a hearing to issue is all based on what's on the paper. 100%, no interview, nothing. So it kind of takes that personal stuff out of it. One of the things that was happening is there were a lot of complaints about the masters interviewing applicants, even though they were recorded. When adverse parties had counsel, there were just a lot of problems with that. Be that as it may, in answer to Mark's question, I think it's really important because the masters understand that domestic violence does not happen just in a vacuum. It's a pattern of conduct, that it's important that you kind of bring in other incidents around the same behaviors. You know, it used to be back in the day when I first started doing this work that applicants could only write on one page. They were not given, you know, it was literally limited to that one page. They were not given additional sheets or anything else. So it was like, oh my God, what does that mean? Some people write big, some people, I mean, it was ridiculous. And so they cut that out pretty quickly. But again, I think it's important that if you're counseling people to help, you know, they're gonna fill out an application, it's important that they think about what they're gonna write. Yes, it's important about what led up to this incident, what was the straw kind of that broke the camel's back, but it's important that you show kind of a continuation or an escalation in behaviors.
Paint the full picture,
Yeah, exactly.
not just the plan.
Exactly, because remember, it's all based on the application, no interviews. Because a lot of times, I mean, I would see people in my office, and I know if there's advocates here, you know, you'll be interviewing people, and they'll tell you, oh yeah, you know, this happened, blah, blah, blah. And then as they're walking out the door, they would turn, I had this one woman, I'll never forget, standing in my doorway, turns around and tells me, oh yeah, I forgot to tell you, he strangled me yesterday. Because that's how memories, that's how trauma works. You know, there's I mean, you can't put everything on the front burner every second or you'd never get out of bed. You'd never get your kids to school, you'd never do what you have to do. And I always found that so profound that it still sticks in my brain, that image of this woman turning around in my doorway saying that, like almost like, oh yeah, I forgot to tell you. So, yeah, I mean, and by the way, I'm not criticizing, I'm just saying that that's exactly how trauma works. So when you're working with your clients, it's important that you help them really spend some time thinking about what they're gonna write, because trauma doesn't happen in a straight line. Memories do not happen in a straight line. People's ability to kind of put things on the front or back burner are not easily moved around. And so that's a really important part that you can provide for them, especially because there's no interview. So in the past, they might have done that with the master when they had their one-on-one interview and said, oh, by the way, but there is no by the way anymore, okay? So I really want to mention that. Yes?
I really don't know exactly what is a master.
Oh, okay. So protection orders I'm sorry, let me rephrase that. There are only 2 counties in Nevada that have masters because it's based on population. So clearly it's going to be Clark County and it's going to be Washoe County. So masters are not judges. They're not. They don't run for election. They're appointed, but they're appointed to hear specific matters. So for example, we have domestic violence masters, we have a child support master in Washoe County, we have one in Clark County. We have a master that hears children who've been removed because of abuse or neglect. They hear those matters. We have masters that hear, we have a juvenile court master that sits up at Jan Evans. So the difference is they're not judges. However, let me be clear, at least in this context, they sign those orders and they're enforceable as if a judge put his or her signature on them. Okay, and that's by law, by statute. Okay, so that's a really good question. You know, in California, I think they call them commissioners. I'm pretty sure they're called commissioners. Yeah, and so they have judicial authority. Their protection orders are full, you know, they're enforceable, but they're not judges. Now, if somebody, let's say the adverse party wants, or the applicant who's been denied a protection order wants to appeal, it gets appealed to district court, and it's the district court judge in the family court. Now, by the way, there's only 2 counties in Nevada that have family courts because they're based on population. So it's Clark and Washoe County. So for example, let's say you were living in Carson, or your client's living in Carson City or in Yerington or something, and they're applying for a protection order. They go before the justice court. So like when I was in private practice, you know, in Lyon County, they may not have to go out to Yerington, they may go to Dayton. I know Rita loves the judges in Dayton. Yeah.
Love that Dayton Justice Court.
So again, they go to justice court and they apply. But that justice court judge who's hearing their protection order matter may an hour later be hearing like a, I don't know, like some issue dealing with removal of property or a contract case, or whether somebody should be bound over on a criminal case. Yeah. Okay. Okay. So there's been a lot of change in the procedures, how people apply. So in the past, they used to go up to the 3rd floor of 1 South Sierra Street, which is where the family court, and that office was run by CAW, which there is no Committee to Aid Abused Women anymore. It's called the Domestic Violence Resource Center. So there were a lot of problems with them being in the courthouse on the 3rd floor. People thought they were part of the court, and they weren't. People did not, I mean, a lot of, mostly men, all men, and their attorneys were very, they used to complain all the time in their pleadings as well that, well, it's the Committee to Aid Abused Women, there's abused men, and you know, what does this mean, and why is it in the courthouse, and why are they being represented, and so it became, there's always a lot of problems with the fact that they were in the courthouse, they weren't part of the court, yet they had access to the masters, they used the court facilities, anyway, there's just a lot of political issues with that, a lot. So, but again, in the old way it was done is that applicants would go up there, they would fill out an application, they would wait around until they were called. Sometimes they would have an interview, sometimes not, and then they would have their protection order. Okay, well, as I said, there is no CAW anymore, it's now the Domestic Violence Resource Center, and there is that office on the 3rd floor, but all they do up there is that they, there's kiosks where applicants can fill out their applications. They can also help you set up what's called an eFlex account. What's an eFlex account? Now by law, all matters that are going forward have to be e-filed. So all attorneys have e-filed accounts, eFlex accounts. But individual applicants in the past, unless they applied for one, didn't have it. But now everyone needs to have one because that's what they said. So that's the truth. So they help you fill out the it's just a real simple thing, and you have an eFlex account. However, if you don't have access to a computer, you're not going to be able to access what's popping up on the eFlex account. So they'll also call you. And a lot of people don't have access, especially people in transition because of domestic violence. Okay, so what happens now? So an applicant wants to apply for a protection order. They need to go to either the law library which is in the old courthouse. They could go to the 3rd floor to apply for a protection order.
3rd floor of what building?
1 South Sierra Street, the new
Okay.
courthouse.
Okay.
They can go to Domestic Violence Resource Center. They could go to Safe Embrace, which is another domestic violence shelter and advocacy center. And they will assist them, not in telling them the law, but they will access them to a kiosk. There are advocates there, and they can fill out their application. Now, if they don't set up an eFlex account right there, the advocates or the people they may not be advocates, they can help them file their protection order. Everything is filed in electronically. The applicants do not physically have to go to the courthouse at that point. Okay, however, they can download these forms too, is my understanding. Now, this has all changed since I've left the unit, but they can download the forms, fill them out, and then they can bring them in to either the Domestic Violence Resource Center or to Safe Embrace or to the 3rd floor, and they will assist them in getting them e-filed. There's no cost to e-file or to file a protection order. There's no filing fee. Every time you file something in the court, you need either a fee waiver or you have to pay money. But with protection orders, there is no filing fee, okay? So the way it works now is that they file it. They're told that you'll be notified electronically, or if you notify them, through their eFlex account, or if you tell them that you don't have an eFlex, or you don't have access to an eFlex account, one of the advocates, somebody will contact you from the court to let you know whether you've received it or not, okay? So this is kind of where it picks up on the handout, because I thought it would be good for you guys to have this. So this is like what happens now. Again, this is all new. This is all completely new. It did not work like that before. Thanks. So it really pretty much, I actually copied this from a packet from an applicant. I thought it would be good for you guys to have it and see. This is what they're telling people. Once your application has been filed, you do not need to wait at the court. In the old days, on the 3rd floor, there were people lined up in there waiting to hear back whether they got it. Their kids were there, they were missing work. It was terrible. I mean, the kids are out of school, they're missing work. I mean, it was really, and there's a lot of people and a lot of kids running around. So they're telling you here, you do not need to wait. It's telling you here, a court employee will call you and let you know if your order was granted, denied, or set for hearing, okay? So my understanding is from the attorney who does this is that you can also elect to be notified through eFlex. But if you don't want to, the court employee will call you just as it says here. Okay, now this is what's given to applicants after they do their application. Okay, and so then it's like, what happens now? So they tell you right here, if the adverse party lives in Washoe County, and that's what they're telling you here, assuming that your application was granted and you now have what's called a temporary protection order, the important thing that you need to know is that the adverse party must be served no later than 45 days from the date of your application. So what happens if you have an adverse party who's evading service? What if you have an adverse party who's in hiding because he or she does not want to be served? So in the old days, when I was doing it, and it changed before I left, if you could not get the adverse party served, that protection order in 45 days, the temporary protection order was dismissed without prejudice. Now that's a real problem. That's a real problem for an applicant who has a very dangerous adverse party out there who's hiding and who's evading service. And remember, what's the rule, the old rule? The adverse party had to be served no later than 45 days from the date of application of the TPO by the applicant, obviously by the applicant, okay? So the law actually changed if you're coming up against that 45 days and that adverse party has not been located, and you get the declaration of service by the sheriff will show they made like 4 attempts, 5 attempts, whatever. you can apply now to extend the period of your temporary protection order. I believe it's I think you can apply for 2 90-day periods. So you can apply to extend your protection order, I believe it's 60 days, to have another opportunity to get the adverse party served. And to keep in mind that, and I used to tell people this in my clinics, the sheriffs are great at doing service, but they're really busy. And if you really are trying to get somebody served, and you could get them served using a process server or whatever, do it. Because the sheriff is just really busy. They're not gonna make numerous attempts. They're not gonna sit outside there for 20 minutes to wait for the adverse party to leave work. But if that's what you need to do to get that party served, it's important to get them served. But it's important that you know that unlike the old days, your temporary protection order will not go away if you file that motion asking for the extension because you've tried to serve the adverse party, in good faith. Here's the declaration of non-service, here's whatever, okay? So the sheriff will do service in Washoe County. What if the adverse party doesn't live in Washoe County? What if the adverse party lives somewhere else? Well, and by the way, I also want to say that in the old days, in the really old days, if an applicant was granted a protection order, he or she had to then go up to Park Boulevard to physically bring the protection order up there to the civil window. There used to be a kiosk in the courthouse from the Washoe County Sheriff's. Once that went away, applicants who had protection orders, TPOs, were having to literally schlep up on a lot of these women, mostly women, didn't have transportation. They were going up to Park Boulevard from the courthouse, which is at, Court Street, downtown. That's not downtown, is that downtown? I don't know. I can't figure out what downtown is here.
It's uptown.
Is that uptown?
Yeah.
I don't know. To me, it's weird. Anyway, so they would have to literally get on a bus, on 2 buses or 3 buses, to get up there to physically bring it. So actually, while I was still doing it, we talked to Judge Weller, who was actually in charge of the protection order office. And he changed that so that the protection order office was able to fax the order. There was also like a cover sheet with description of the adverse party and all kinds of information. And so it's now the same, that they do not have to physically go up there. However, if you notice on here, it says, I'm looking at the second full paragraph. It says how they'll try to serve them. Now, orders that require the adverse party to be removed from a shared residence must be taken in person. So they stuck this back in here. I mean, because clearly that is one of the things you're going to be asking for. If you're cohabiting with a batterer, you're going to want to exclude the batterer from your residence. So here we are again, and this had been taken out. It looks like they put it back in. I noticed that before I came here today. So if you're asking that the adverse party leave the residence that you share with him or her, you have to physically bring it up there. Why? Well, nobody cares what I think, but it's ridiculous. Okay? Now, what if you have an adverse party who doesn't reside in Washoe County? Obviously, the Washoe County Sheriff is not going to be able to do that service. So let's say the person resides in Carson City or Lyon County. You're going to have to, well, you could usually make arrangements to fax it to them. But obviously, it's going to have to be a sheriff of that county where the adverse party is found. Maybe the adverse party can't be found residentially in Washoe, but you know that they work at Tesla, and they work on it, which is, I believe, Story County. And so you might want to have the Story County Sheriff or a process server serve the adverse party when he or she begins or gets off a shift, right? Because that would be the way to do it. Because you don't know where they're residing, they're hiding, but you know they're going to work because they want the money. And that would be a way to get that person served. But clearly, the sheriff of Washoe County is not going to do that because they don't live here. Or they don't work here. Or they may live here, but, yeah, they can't be found here. So you need to get the person served any way that you can. Because although you're going to get an extension of time, rather than just getting your TPO thrown out, at some point, if you cannot get that party served, your TPO is going to go away. It's just what it says. It's a temporary protection order. So I want to stop here, and also let me just mention that sometimes the adverse party may not even be in this state. They might be in California. You're going to have to get a sheriff from that county or a private process server to serve them. One of the issues that comes up a lot is, and you should think about this as, advocates or as people helping clients, you need to think about, where did the acts of domestic violence occur? Did they occur in Nevada, or did they occur somewhere else? Because if there's no, I don't want to get into this too much, but if there's no nexus with Nevada, in other words, that the acts occurred here, but one of the things you want to talk to your clients about, were there emails back and forth? Were there text messages? Were there letters? In other words, was there communication from California to Nevada? That will give Nevada jurisdiction. But it's important that even if not all of the acts, you have to be able to show that the domestic violence happened in Nevada. You could show that through text messages, through emails. And that's another thing you need to tell your clients, is to start saving text messages, start saving emails, taking a look at other social media, looking at Facebook before they get blocked off of the adverse party's Facebook. They should be printing all that stuff out. Okay, it's really, really important. So before we talk about what happens at a hearing, and I don't even know, let me see what time it is. Wow, it's 1:49. Yikes. But I do want to stop though, and sometimes people have questions about the service part, about jurisdiction, which, believe it or not, used to be a really big deal. It's less so now, but this issue of, he's not even in the state, Your Honor, he's not even a threat to my client. That's baloney. That's ridiculous. Yeah, it's not really hard to travel between Sacramento and Nevada, is it? No. But I just want to ask if people have any questions. Okay, so I just looked at the time, and we only have about 10 minutes. Let's talk about, you get to the hearing, okay? So you get to the hearing. Let's say your client doesn't have an attorney. A domestic violence advocate can sit with that person at counsel table. However, to be clear about it, they cannot talk to the client. The client can't ask them questions. They're there just for emotional support, okay? The adverse party may have a lawyer with him or her. That's fine, okay? Since we only have 10 minutes left, and we did already talk about the issue that a criminal no contact is very limited, very circumscribed to that victim and that situation. In a protection order, a lot of these people have children together. So the court does have the power, they do have the jurisdiction to enter what are called temporary custodial orders between the parties, okay? And I will tell you that that is a huge problem, because abusers now have moved on from abusing the victim survivor to using the children as a way of controlling the victim. And that is so common. The problems that happen at exchanges, all the problems have now been, a lot of the control, a lot of the abuse now gets transferred in the exchange of these kids and what happens, during the time that the abuser gets to spend with the children. Clearly, there is a statute in Nevada that each parent is entitled to a full relationship with the child. However, the good part is, because we do have domestic violence masters, they're somewhat sensitive to the issues of how abusers control and use children to further victimize the victim. So the court will enter custody orders, temporary. That doesn't mean that it's not going to get changed in a custody case or in a divorce. You guys probably know that we have a peace center here in Reno where there can be supervised visitations. Again, if there's anything where there's been a criminal case too, the courts won't hesitate. There's a slot. Both parties do not get there at the same time. And they have a slot where they see the kids. It's actually really nice inside the Peace Center too. I mean, as nice as it can be. You can also use the Peace Center as an exchange location when it's open. And I always recommend that if you can, and they have published times when they do when they're open for supervised visit slots, when they're open to do exchanges. If you're able to get a slot to do an exchange at the Peace Center, it's a really good thing to do. Because people are always like, yeah, I want to do it at the police station. Well, first of all, the police or the sheriff, I want to do it at Park Boulevard. The police do, they don't want to get involved in it. I would always argue, Your Honor, we want to do it there because there are a lot of cameras. And there are a lot of cameras there. So I would always ask for it to be like in the vestibule, in between the outside doors and the indoor. But, you know, judges are like, well, yeah, let's just do it at the 7-Eleven across the street. Well, if they could do it at the 7-Eleven, then what the hell are we doing here? I mean, what do we need you for? We already know that the 7-Eleven is across the street. You're supposed to be here to help protect these kids. So I'm just saying that that's the job of a really, now by the way, that's not how I put it in court. That's how I feel in court. But it's really important that, it's very difficult. I can only imagine what it must be like to be a victim survivor and be there by yourself with your abuser sitting like the distance from where I am to where that chair is on the end. How hard is that? You gotta tell people to write things down. Not that they're gonna read it, but then they'll remember. It'll be like a checklist. I mean, who the hell under pressure remembers everything that you're supposed to remember in your own life? And you add to that the safety of your children. I do want to tell you something really important that you should really think about when you have clients. A protection order by statute and state law will say, actually it's federal law, will say that the abuser cannot interfere with the use of utilities, interruption of utilities, that kind of thing. Because a lot of these abusers will try to turn off electric. However, that's all well and good, but your job is to make sure that you inform your clients that that doesn't address who's going to pay the bill. And paying the bill is a completely separate story from not interfering. So here's the deal. I didn't interfere. You didn't tell me I had to pay the electric bill. So it's, right, that's different. Interfering has a specific definition. Okay, paying the bill means paying the bill. So it's important that you think about that. It's the same thing with a mortgage. It's the same thing with car payments. Okay, it's great that people are married and there's these presumptions. Yeah, but here's the deal, Mazda wants their payment every month. They don't really give they don't care. Okay, so all of this you need to think about because this is your client's first opportunity, usually, to get some temporary orders. By the time they get into court, the car may be repoed, okay? Because it doesn't happen like right away. Okay, so you gotta really think about that. How is this woman gonna survive? What do I need? Do I need interim support? Now, they're not gonna give you alimony, but they can give you what's called household support. That's when people are married. I'm not gonna go into the problems when people aren't. The point is you need to think about this, okay? If people have children, you need to think about, is there a child support case? Or do I need to tell this judge, Your Honor, the statute says that you have, they don't like this, it's too bad. The statute says you have the authority to give my client child support and she needs it. Well, counsel, I don't have all the financial information. Yeah, that's fine, that's fine. My client will testify to what the adverse party makes. And let's see if he denies that. You gotta fight, you gotta get in there and fight for your client. Because otherwise, again, this is kind of summing up, domestic violence is an economic crime too. It's all about economic control. And it's, yeah. The hearings kind of happen on a stacked calendar. They're on the first floor of 1 South Sierra Street. They've changed the law. This is a really important change. It used to be that the masters could grant it for anywhere from 1 month to 1 year. They've now changed the statute as of July 1st. You can get an extended protection order for up to 2 years now. Okay, so in a case like I've had cases where, you know, these adverse parties have tried to murder, kill clients. That's clearly a 2-year protection order. Remember, the guy's probably going to go to the pokey anyway. But the point is that you can still get the civil protection order for up to 2 years. And there's no requirement that there be a review hearing, for example, after the first year. Okay. So the other thing is, in this packet, on page 3, there's a getting free legal assistance to TPO applicants. This is actually given to TPO applicants in their packet. And this talks about Washoe Legal Services and what happens at the clinics. Washoe Legal Services does a clinic every Wednesday. On the following page, in the packet that's given to applicants, it tells them that every Tuesday, which I've done, they always have 2 attorneys there. There's a family law night at the Washoe County Law Library, which is located in the old courthouse. Okay, that's every Tuesday. That's another resource for people. They're also given, the next page has domestic violence resources, and this is a really important thing for all of you to have as well. Now, I also included on the last 2 pages, the last 3 pages, the power and control wheel, because this is really where it starts. And so, again, there's different kinds of power and control. I mentioned briefly the issue with sex. It's not only forcing victims to have sex, it's not allowing them to use birth control. It's a huge issue, and people don't even realize that. Children, or punishing them for finding out that they are utilizing birth control. There's a children's domestic abuse wheel, which I think is fabulous. Really, take a look at it. It's fantastic. And then, of course, we have an equality wheel here. And then on the very last page, there's healthy, unhealthy, and abusive. I mean, it's such a huge problem. Right. So I'm going to stop because it is 2 o'clock. But I mean, I'm happy to take any questions that people have. I know it's a lot of information, but it's really important information. It really is.
Is there still a safe room where one of the applicant can not have to sit and stare down the other party's group waiting for the hearing to start?
Yes, there is. They can wait up on the 3rd floor in that room. That used to be the TPO office, but is now, yes. And they can wait up there and they'll get called when the hearing is happening.
One thing that struck me is under courtroom rules,
Yes.
under number 3,
Mhm.
it says it's a stacked calendar and all parties to each case may be in the courtroom waiting their turn.
Well, they can be, but like a victim survivor should be upstairs. You have to let the bailiff know, Ms. Smith is going to be waiting on the 3rd floor.
Good.
Thank you, everybody.
Thank you, Caryn.
Yeah.
Thank you.
If you guys would fill out that second